It may be tempting to try and pursue a title using an abandoned vehicle declaration, but in most states, including the state of Florida, that may not be the way to go. We're going to take a look at a couple statutes from Florida about getting a title for a vehicle which did not receive paperwork, and also abandoned vehicles. It's very dangerous to claim that a vehicle is abandoned, because in most states, once you say the word abandoned, it triggers a definition of that vehicle which may not allow you to get a title. In fact, in some of the statutes in Florida, an abandoned motor vehicle means a vehicle that has been disposed of on a public use. This is about airports, but in other areas, wrecked, inoperative, or partially dismantled condition, or a motor vehicle has been maintained in idle state. The reason why that is important to know is, in some cases, if you say the vehicle is abandoned, the state is not allowed to issue you a title that's a valid title. They can only issue a parts or junk title. So be very careful with abandoned and how you use that term. However, most times when somebody is looking to get an abandoned vehicle title, it's really a title for a vehicle which you own, but you did not receive a title at the time you purchased it, or that you lost it afterwards. And there are processes for this. You've probably seen on our website things like a bonded title, which is different than abandoned title. You've also seen court order titles. There are processes in every state to get a title when you're missing paperwork. So here's the information from Pinellas County in Florida. We've been working with a client for some vehicles here, and they'll tell you very clearly it is sometimes possible to be issued a title for a vehicle that you own, did not receive a title. Notice, sometimes possible is in bold and underlined. They want to make it very clear. This is not a slam dunk. Vehicles are not finders keepers. If you do not have a title for the vehicle, it's questionable whether or not you're going to get one. Now, there's a lot of things that you can try to do that most of the time work, especially if it's done correctly and the professional does the process. Many times it will work, but the DMV has many reasons not to give you a title. In fact, it tells you right here, you must do all of the following. Not only is that bold, not only is it underlined, but it's capital. Before a court will consider an order, you must take the following steps. You must make a diligent search to locate the former owner to transfer title. Ask the owner. You must provide a bill of sale, canceled check, letter, something proving your right to ownership. If the former owner has moved from the area without leaving a forward address, you must send it to the last known address and file an unopened letter with the circuit court. Then you must get an affidavit from the sheriff's office establishing that the vehicle has not been reported stolen with the VIN number, not an odometer statement. Then you will need to complete an affidavit for vehicle title and an affidavit saying you did the diligent search. Both documents must be notarized. Again, this seems like it's important. It's capital and it's underlined. Provide documentation of the value of the vehicle. You can use NADA, Kelley Blue Book, or a professional appraisal. Capital again, you must file your completed paperwork with the circuit court. They'll have a filing fee. If you can't afford it, you can ask to waive it if you're poor. After you filed your paperwork, your case will be reviewed by the staff and forwarded to a judge for consideration. In most cases, you won't have to appear in court. So, if the judge signs the order, you will be mailed a true copy, and then you can bring that to the DMV to get a title. Be advised, you cannot use this process if there is a lien on the vehicle. If there was a previous lien, you have to have a lien release, lien satisfaction. And it can't be worth more than $30,000. Look, that's 12 things on the list. Are there any more? No, there's no more. So you have to do all these 12 things. And then, remember the first thing they said, it's sometimes possible, even if you do all those things. What are the forms you need? Here's the affidavit for vehicle. Put your name, the vehicle information, previous owner. I've conducted a diligent search. Get it notarized. Pointers for completing a diligent search. Postmaster search for previous owner. Phone directories. A list of actions a court may find are reasonable. So You may want to do some of these things and document it because the court may ask you, what did you do to try to find the owner? And if you can't prove that you did these things, that might be the reason that they don't allow it. So a court order title is a very good process for getting a title. But remember, just because you have possession of the vehicle and the keys and the VIN number doesn't automatically make you the owner. The court has to say it's okay. Many times they will. If you take the matter seriously, you type up the right forms, you get the right affidavits, and you are diligent about it, it's probably going to work. But if it turns out there's liens on the vehicle, it's stolen, the last owner wants it back, or something comes up where it's not a clean, smooth process, somebody can test this, it may not work. So, what does that mean for you? Well, we can assist you with this, but remember, it's up to the court to decide whether or not they're going to hand you a title. So if you're worried about having an expense to try to do this, you can do it yourself for free. That's what these videos are for, to give you instructions. We can still assist you as a convenience, but remember, the court may still decide to say, no, you can't have a title because of your story doesn't match. Now, what makes one story good and one story bad? Really, it's up to the judge. Sometimes it's a personal opinion. The judge on one day might decide, yes, this is good. 2 days later, a different judge with the same story might say no. It's totally subjective. But we recommend getting everything very thorough. If you type everything out instead of scratching at handwriting, if you have lots of good documentation, you have everything notarized. Here's a notary stamp right here, a place for it. If you have very, very good documentation that you did all of these steps that are required, it's more likely the judge is going to say, yeah, this person took this seriously. They took the time to go through this and didn't just kind of randomly throw something on my desk to ask me to give a title. Remember, this form and this video isn't legal advice. If you have questions you really want to get an answer to, you can call a lawyer. It's going to cost you money. But you don't necessarily have to get a lawyer if you think you can read through this, or you can get some assistance on getting documents prepared for you in advance. Abandoned titles seem like a tempting way to go, but abandoned vehicles in most instances are not finders keepers. A court order title is a good backup method, so is a bonded title. Be aware of all your rights for your title so that you can get a vehicle transferred to your name.